in the matter of petitioner Charles Paul Nerswick versus respondent Lindsay Ann Dineski. Ms. Dineski, please state your name for the record.
Lindsay Dineski.
Please raise your right hand. You solemnly swear to affirm any testimony you provide to the court today will be the truth and nothing but the truth.
I always tell the truth.
Well, that's a lie. Hey guys, and welcome to today's video. Today we have the continuation of the Lindsay Dineski saga, with part 4 taking a slight detour from the original plan. Lindsay Dineski was recently arrested for resisting arrest after allegedly refusing to exit her vehicle when instructed by police. Ignoring a lawful order during an arrest situation is risky at the best of times, and even more so when there is reportedly an active warrant involved. I've already submitted a request for the bodycam footage, so while we wait to see exactly how that unfolded, we're heading back to familiar territory. In the meantime, let's watch a wild sovereign citizen Karen in her natural habitat. The courtroom, so let's begin.
Dineski, we had a bench warrant to issue for your arrest back in December 4th, 2003.
There was no proper service on that. I was never given any service on that warrant, so it's invalid.
So the warrant issued because you failed to appear
For a court that I never received any service on.
for the show cause hearing. I do see that proof of service.
I was in another state, so there's no way I received any proof of service, and you guys had my email and my phone number, and nobody ever contacted me, so this needs to be thrown out immediately.
So that's not how the court.
Yes, it's what the law says. The law says if I do not have proper service, it's an invalid warrant.
That's actually true, but in Lindsay's case, it likely doesn't change much because she moved from that address and apparently never updated the court with a new one under Michigan Court Rules 2.107. Service can generally be made to a party's last known address listed in the court record or filings. In practical terms, if someone changes address and fails to notify the court, documents may still be considered properly served at the previous address, so whether the move was voluntary or the result of other circumstances, the responsibility to keep contact information current usually remains with the party involved. Failing to do that can create serious problems later when hearings, notices, or orders are issued. The court then steps away briefly to verify whether service was properly completed. And the moment the judge returns, Lindsay is ready to continue without missing a beat.
Okay, Miss.
Me under trial on this matter because I've never been able to present any evidence. This is my hearing and I'm allowed to speak at my own hearing.
I have to let you know I'm arraigning you.
You're reading it on an invalid warrant. This needs to be dropped immediately. Is this an Article 1 court or an Article 3 court? Because if this is not an Article 3 court, you have no right to adjudicate anything to do with my liberty interests. And my children are my liberty interests, and they are my offspring. And this man attacked me, so this entire PPO is based on fraud and is void. So that not only can you not arraign me, but you need to overturn the PPO immediately.
So, Ms. Dineski, you were served on October 23rd, 2023. There was a show cause hearing for a violation of the PPO that occurred on December 4th, 2023. Just for the record, I have muted Ms. Dineski because she refused to be quiet.
You're not allowed to mute me at my hearing. Is this an Article 3 court or an Article 1 court, ma'am? You have to answer me. Are you an Article 1 judge? Because if you are, President Trump said that you are not allowed to hear anything to do with my liberty interests in his executive order that he recently put out.
All right. So
are you Article?
Is that you stopped Mr. Nerswick's mail? You were interfering with his mail, Ms. Nerswick, and wasn't able to receive his mail.
If you do not have a constitutional oath, then you have to recuse yourself immediately and let me have an Article 3 judge, because this has to do with my constitutional rights. And Article 1 judges.
So the court is in receipt of a customer information form that
appears. You do not consent to this PPO, and you must prove and show your oath.
USPS. At an address of 18337 Ewell Road, Belleville, Michigan.
I was not living there. I had been evicted from there previously in June. So there was no proper service.
The petitioner filed a motion complaining that you, Ms. Dineski, stopped his mail.
I didn't stop anybody's mail. He came and stole my mail and signed for a certified letter that he sent me, so I didn't receive it. And you guys won't let me show evidence. This has been going on for over a year, and I've never once been able to show evidence, and I've demanded a trial multiple times, and you've denied me a trial. So you're going to be going to prison under USC 18, 241 and 242, and I'm going to be asking for the death penalty for you.
Lindsay never seems to stop talking. The judge then steps away briefly, only to return and announce that the hearing will be pushed back a few hours while they wait for a prosecutor. In many jurisdictions, routine arraignments of this type can often proceed without a prosecutor being physically present, depending on the charges and local procedure. But with Lindsay involved, nothing ever seems to stay routine for long. She has a way of turning even the most straightforward hearing into something unnecessarily complicated.
This is also a bill of payment penalties, which has been outlawed by the Constitution, Article 1, Section 9, Clause 3. You are using an unlawful PPO to withhold me from my offspring, which qualifies as kidnapping and hostage taking and treason and torture. This matter is void ab initio from the beginning because it's based on fraud, and fraud vitiates everything. Marbury versus Madison, anything repugnant to the Constitution is void. This is a violation of my free speech. This is a violation of my right to petition the government for redress of grievances. It's a violation of my Second Amendment because you said I couldn't have a weapon or bear arms.
Ms. Danelski, I'm going to put you in the breakout room with Ms.
This is a violation of my Fifth Amendment. This is a violation of my Sixth Amendment. This is a violation of my Seventh Amendment. This is a violation of my Eighth Amendment right, my inalienable Eighth Amendment right. This is a violation of my Ninth and Tenth Amendment rights. You are violating all of my rights, and I have not ever been allowed to be heard. Due process allows me the right to be heard, and this has been ongoing since 2023, and I have never had the right to be heard. And I've had my babies unlawfully held from me based on fraud, which I never got to present evidence to prove otherwise.
Well then, stop asking pointless questions. A few hours later, the prosecutor arrives, and the hearing finally resumes. School. It can, particularly when a criminal element is involved. For example, violating or ignoring a court-ordered protective order can result in criminal charges, even if the original matter began as a civil case. That's an important distinction many people miss. A case may start in civil court, but certain conduct afterward, such as breaching a court order, can create separate criminal liability.
Okay, we don't have a prosecutor. I'm putting this over. I want to reconvene at 2:00.
I'm demanding a quo warranto.
All right.
And
Deputy, did you hear me? Officer?
Your Honor, I do have a 2:00. Did you want me to come back? I have a 2:00 in judgment.
I don't need an attorney. I don't consent to an attorney.
Yeah, I can't. I don't have a prosecutor. I need you to come back. What about 2:30?
I want to say something. You guys are.
Miss Williams,
Your Honor, I'm talking to
5 days.
I have no prosecutor.
I was not even notified of this court. I was not even given notice of this court date, and I've been here.
So let's say 1:45. I don't have a prosecutor.
You need to be quiet. This is my hearing.
Can we do 1:45, officer?
Yeah, 1:45.
Okay.
All right, we'll see y'all back at 1:45.
Okay, thank you, Your Honor.
I do have one question.
Go ahead, officer.
Just for staffing purposes, can you give a time, because that's right around shift change, do you think that hearing would be done by 2:30, or are
I'm waiting on the prosecutor? I can't.
Well, it has
the record is going now. I can't call it. So,
prosecutor, I'm asking for this to be dropped.
Yeah, 1:45 is the time that I have.
Why won't you answer any of my questions?
Your Honor, I'll see you at 1:45. Thank you.
Sounds good.
You just ignore my questions.
What are you even talking about? Of course, you would want things handled procedurally, especially if you believe your rights are being violated. Procedure is exactly how courts protect fairness, preserve objections, and create a record for review. You've already cited multiple Michigan court rules provisions during this hearing, which shows you're relying on the same procedural framework you claim to reject. In other words, by invoking those rules and trying to proceed pro se, you're participating in the process and using procedure to support your own position, so the argument undercuts itself. If procedure matters when it helps you, it matters when it governs the whole case.
I do believe arraignments can take place without the prosecutor's office, but
I kind of thought so. I did start, but for this particular one,
Yeah, this one, I think.
considering the fact that, you know,
yeah,
this is, we needed you here. That's why I started off and I was like, oh no, let me.
Leslie, as far as the allegations go, I do believe that this is a bench-borne arraignment.
Hold on. Yep, it is. Let me start to call the case. All right, CJC, are you there? I want to call the case, but I want to hear from you.
Yes.
All right. All right. Thank you. Let me call the case.
Recording in
This
progress.
is case number 23-104850-PP in the matter of Charles Nurswick versus Lindsay Ann Dineski. Mr. Tudge, if I could get your appearance for the prosecutor's office.
Good afternoon, Your Honor. Gregory Tudge, P85961 for the people.
All right, Ms. Fort Williams, your appearance, please.
Good afternoon, Your Honor. Gail Fort Williams, P35963, counsel on behalf of
All right, Ms. Fort Williams, you had an opportunity to speak with Ms. Dineski in the breakout room.
Why is there still an attorney on my case when I said I don't want one?
I attempted to speak with her, Your Honor.
I do not want or need an attorney.
All right, Ms. Fort Williams, I just want you to stand by at this time, if you can do that.
And I'm entitled to relief from judgment under Michigan Court Rule 2.612 because I was not personally notified of this matter. And so it needs to be dismissed immediately.
Ms. Dineski, you were arrested for a warrant issue because of your failure to appear.
A failure to appear on something I was not personally notified on. So under Court Rule 2.6123, not personally notified, I am entitled to relief from this proceeding and action.
Hey, let me hear from Mr. Tudge. Go ahead, Mr. Tudge.
Your Honor, it does appear that 2.512, I believe, was the citation, which 2.516.
I'm sorry, 2.612.
Chapter 2 of the Michigan Court Rules governs the civil procedures. This being a quasi-criminal matter,
This is a civil procedure because it's family court.
Hold on, Ms. Dineski, let Mr. Tudge speak.
It's not quasi-criminal, this is civil.
All right.
So that's a twisting. This is a family court matter.
Ms. Dineski, please let Mr. Tudge speak first, please. Go ahead, Mr. Tudge.
I thought this was my hearing. I should be the one speaking.
Mr. Tudge is from the prosecutor's office.
He doesn't need to be on this case because it's civil. Prosecution doesn't happen on civil cases.
Because courts do not dismiss cases simply because a party angrily demands it, though dismissal normally requires a recognized legal basis, such as lack of jurisdiction, defective service, insufficient evidence, procedural violations, or another valid ground supported by law. Judges are expected to rule on legal standards and facts, not on who is the loudest or most demanding in the courtroom, so frustration alone is not a motion, and demanding dismissal is not the same as earning one.
All right, go ahead, Mr. Tudge.
Thank you, Your Honor. The MCR 2.612 does appear to be governing civil proceedings. This matter being a quasi-criminal proceeding does and is controlled by the court rules which address misdemeanor offenses, unless otherwise stated in Chapter 3 under special proceeding. I do believe that the cited rule is inapplicable for this proceeding.
You may proceed.
I'm sorry, I didn't hear him. Did he say applicable or inapplicable?
It is applicable, Ms.
Oh, okay.
Okay, go ahead.
Your Honor, I I must correct the court. The argument is not applicable, inapplicable.
Oh, he said not applicable.
Why would it be inapplicable?
He's
if
saying
this
your
was-
court rule, he's saying the court rule your side, his position, and I agree with him. Let me just say that for the record, that the court rule your side, it governs civil procedure. It doesn't govern under quasi criminal matters.
This is not a criminal matter. This is a civil matter.
Which
It's
is
a
why you're in jail.
It's a domestic matter. How is that criminal?
Ms. Dineski.
And in criminal procedure, it's the same thing. These also, the criminal code
Ms.
also.
Dineski, you have to.
Ma'am, the reason why I looked up the.
I'll
civil
give
code
you
is
an
because it's a
opportunity to
civil-
speak, but I need to hear from Mr. Tudge first.
But it's my hearing. I should be heard first. This is
No.
my hearing. I'm the one who's supposed to be heard, not the prosecutor.
But they're being heard because you're violated a PPO.
I didn't violate anything. I was not
I'm
notified
sorry,
of
the
anything.
allegation that you violated a PPO.
Okay, well, then I have a right to say was not
I'm
notified.
going to give you that opportunity, but you have to, the allegation is that you violated a PPO. You have to let the prosecutor's office, the representative of the attorney from the prosecutor's office speak. Go ahead, Mr. Tudge.
Your Honor, I don't believe I have anything further as to the argument. As it relates, I would ask that the arraignment for the bench warrant continue. And I would also ask that the court inform the respondent of the standards for which respondent will be held if proceeding pro se. And I believe it would be appropriate to.
I'm proceeding sui juris and
Well,
persona.
I am going to ask Ms. Fort Williams to operate.
No,
as
I don't
my-
want an attorney. I do
and
not
my
consent to an attorney.
Ms. Dineski, I have acknowledged the fact that you are not wanting an attorney.
No, I refuse it. It's not that I don't want one.
I
I
have Ms.
refuse it.
Fort Williams to stand by. She's just gonna stand by.
Even though I
What else would
appreciate
you like to say, Mr. Tudge?
I believe it may be of benefit for the court to voir dire or Attorney Williams to voir dire respondent as to a right to have counsel and whether respondent knowingly, intelligently, and voluntarily waives the right to counsel.
All right, Ms. Dineski, you
Your Honor.
understand? Go ahead, Ms. Fort Williams.
Your Honor, I just wanted to say, Ms. Dineski was speaking about being served with the violation, and she's indicating that she was not served. She may have been quoting the incorrect court rule. I don't know. I don't have the court rules in front of me. It doesn't matter, though. Either way, of course, anybody in court has to be served with the appropriate papers. What she is indicating is that she was not served. And I indicated to her, but I don't think she was listening to me because she was talking and I couldn't talk. I indicated to her that this is an arraignment and that she will have the opportunity to address service or lack thereof, if that is the case, when a trial is set or whatever is set.
No, according to versus McVicker, I can challenge us at any time. At any time.
Your Honor, Ms. Dineski, you have to be quiet. For purposes of what she was indicating, Your Honor, it is true that everyone has to be served. I don't know about that court rule, and it doesn't matter whether she's quoting all these rules. It doesn't matter. She's indicating she wasn't served. That's all. Thank you.
Thank you. But the thing is that it doesn't matter if this is
Hold
an
on,
arraignment or not.
Miss. Procedurally, there are things we have to do, Mr.
No, not if my rights are violated.